this 14th annual Supreme Court Term in Review panel, sponsored by the American Constitution Society, Chicago Lawyer Chapter, the ACLU of Illinois, and PILI, the Public Interest Law Initiative. My name is Steve Sanders. I'll be moderating the panel today. I'm on the faculty at the Indiana University Maurer School of Law in Bloomington, and I'm an alumnus of this great law firm and this great Chicago legal community. We're hosted by, as we have been for so many years, Mayor Brown, one of the nation's best appellate and Supreme Court practices and one of the world's great law firms. So we want to thank them for their generosity, not only in providing space and facilities and staff support, but also for the very nice lunch that Mayor Brown also provides each year. So thank you to Josh Yount, who's in the back, who helps with the arrangements, to Robert Hellman, a legendary partner at Mayor Brown and great supporter of ACS, Heidi Dabrowski, my fellow IU alumna and conference services manager here. Thanks also to people on the board and staff of the American Constitution Society, especially Scott Richard, who couldn't be here today but makes all the arrangements, Dana Pownell, who's the chapter president here in Chicago, and Ryan Estes from ACS as well. If you need CLE credit, there is sign up in the back. You can take care of that after the event. This has been approved or at least applied for CLE credit. If you're one of those people who's late, who's now has to get done by the end of July if you missed the end of June. Our format today is that each of my colleagues here will take up to about 10 minutes, no more than 10 minutes, right? We have litigators and law professors here, have to keep them on a short leash sometime. But take about 10 minutes altogether to discuss one or two cases from the most recent term, or in one case, I think, a cert grant that they know will be of interest to this particular group. And then we'll move into a more general discussion. We'll spend some time just having a conversation among the panel about the current state of the court, how frightened we should be by new Justice Gorsuch, and what we might expect next term. And then we always try to leave some time at the end for questions and answers from the audience, and we promise to get you out of here by 1:30. So let me introduce our panelists, and I think we're going to start from that end and just go in order with their presentations. Susan Bandas is Centennial Distinguished Professor of Law at DePaul College of Law. Susan is also one of the 20 most cited law professors in criminal law and criminal procedure, as well as a pioneer in the emerging study of the role of emotion in law. And Susan, I think the current Supreme Court leaves us with lots of different emotions that you can help us with. Next, Michael Scodro, a partner here in Mayor Brown's Chicago office and a member of the Supreme Court and Appellate Practice Group. Mike is the former Illinois Solicitor General for the state of Illinois, where he oversaw the civil and criminal appeals divisions of the Attorney General's office. Next, on my right, Steve Schwinn, a professor at John Marshall Law School and director of its clinical programs. Steve is the co-editor of the Constitutional Law Prof blog, which I find to be a tremendous resource, and is also heading up a new initiative for ACS nationally, a Supreme Court Term in Review online journal that will feature essays by Supreme Court scholars and experts about key cases of the just ended term each year. And finally, Colleen Connell, the longtime executive director of the ACLU of Illinois. As executive director, Colleen oversees the organization's legal, legislative, and educational programs. She's an accomplished litigator on privacy, reproductive rights, and other issues, and recipient, the first recipient actually, of the ACS Chicago Lawyer Chapter's Ruth Goldman Award. So with that, I'm going to ask Susan Bandas to get us started.
Thanks for inviting me. How's the mic? It's okay. Thanks, Steve. This is always one of my favorite events of the year, and Steve always does an amazing job putting it together, so I'm really pleased to be part of it. I'm going to talk about a Fourth Amendment case, and then I'm going to talk about a cert grant, as Steve mentioned, because I think it's so important that I want to give us a little head start on thinking about it. So the case is called County of LA versus Mendez, and I'm actually going to start putting this in context by reminding you of something I'm sure you all all remember quite well, which is the story of Tamir Rice in Cleveland. If you will recall, Tamir Rice was 12 years old. He was playing in a Cleveland park one day. 911 call came in saying that a man was in the park wielding a gun. Apparently, some of the information that it might have been a very young man or a child and that it might have been a toy gun did not get conveyed to the police. So the police officer, Officer Lohman, and at least one other person jump in the police car, speed directly across the park, and come to a stop immediately next to Tamir Rice. And what's important to understand about that is that what he did, especially given the fact that he thought there was an armed man, violated a whole number of good police practices. Once he had put himself right next to Tamir Rice, he couldn't negotiate or talk to him. He couldn't seek cover if he needed to do so. He couldn't ask Rice to put his hands up. He had basically put himself in a position which left him very few options. And once he was in that position, he said, thinking that the gun was a real gun, that he was in fear for his life. And 2 seconds later, he had shot and killed Tamir Rice. So, of course, these stories are increasingly in the news. And, of course, it's also increasingly in the news that no matter how ill-advised the police conduct, there seem to be virtually never any consequences. So the case of County versus LA versus Mendez is important because it helps explain to us one of the reasons why civil liability is so hard to achieve in these cases. And yet it also opens up a little window for hope. So my first reaction when you talked about emotions was be very afraid, but I think hope is really important too. So Graham versus Connor, the 1989 case that shapes excessive force doctrine and tells police when they have exceeded the Fourth Amendment's allotment of force, asks, was the use of force objectively reasonable from the point of view of the police officer at the time he used the force? And that is the key. So let's say that it was reasonable for a police officer who is 2 inches away from someone he thinks has a loaded gun to shoot that person. What about the fact that he, through a series of his own violations of policy and errors, put himself in that position in the first place? Should that matter? And that is what County versus LA addresses. It's an appeal from a Ninth Circuit case, which, as so often, turns out to be part of the story. The police are searching for an armed parolee. They come to a house, they search the house. Behind the house, they see a little shack. They burst into the shack, and having done so, they have now violated the Fourth Amendment, according to the lower court, in 2 ways. They didn't have a search warrant, and they didn't knock and announce their presence. Hearing the intruders, Mendez gets out of bed, grabs his BB gun. According to his own testimony, he does so because it's right next to him and he needs to grab it just to get out of bed in the first place. The police see him with the BB gun and open fire, shooting and severely injuring Mendez and his companion Garcia. So one might think that what happened was an entirely predictable consequence of the police bursting in without announcing themselves. Avoiding situations like this is pretty much the core reason we have a knock and announce rule, so that subjects A can know that it's the police and not an intruder bursting in, and B can allow themselves to give themselves up in a dignified and safe manner. So the Ninth Circuit had a unique response to this issue, as it so often does, and as so often happens, the Supreme Court did not like the Ninth Circuit's unique approach. In the Section 1983 civil rights suit brought by Mendez, the Ninth Circuit used what it called the provocation rule, provocation doctrine, which says that it was the officer's own unconstitutional conduct in bursting in that provoked the confrontation, and therefore the resulting police force was ultimately unreasonable. It held that the officers had brought it about by entering with no warrant and with no warning. So we have an 8-0 opinion before Justice Gorsuch is involved, rejecting the rule, the provocation rule, vacating the $4 million damage award to Mendez and his girlfriend Garcia. And it said we've got to approach every step of the encounter separately. If at the time the officer was faced with the BB gun wielding man, he felt reasonable fear that required deadly force, he gets to use it, no matter what mistakes he made that got himself in the situation in the first place. Now here's the hope, here's the promising area. The court remands to determine whether the violations of the Constitution were the proximate cause of the eventual shooting, which is an interesting question. In this case, I'm pretty sure the petitioners are going to lose for what we could call a technical reason, although the lower court did hold that the police should have knocked and announced. It also held that there was no clearly established law that you have to knock and announce at a little shack, and therefore there was no civil liability for that second step, that knocking and announcing, and therefore there will be no liability for the ultimate force. But consider a more straightforward case. How am I doing on time?
Great. 3 more minutes.
Okay. Consider a more straightforward case, which there was an Atlanta case involving a 90-year-old woman named Catherine Johnston, in which the police used a battering ram to break down her door on a bad tip. And she, hearing a battering ram, pulled out her little pistol to defend herself. The police, seeing her pistol, killed her in a barrage of bullets. So in a situation like that, also, the knock and announce failure is the proximate cause of the ultimate use of deadly force. In this case, it should have been clearly established law. So if the court is willing to open up a window like that, then we might actually be able to take police, the whole sequence of police conduct into account a little bit more than we do now, and that would be a good thing. Okay, so briefly, the cert grant is the case is Carpenter versus United States, and this could be a potentially major case on search and seizure. The case itself involves historical cell site records, but it raises the huge Fourth Amendment issue of what's called the third-party doctrine. So briefly, historical cell site records, and fans of Serial might remember that they played a huge role in trying to figure out where the suspects were at various times in that case. They show over time where we've been making our calls from and who we've been making our calls to. And in this case, the police got 127 days worth of historical cell phone records showing where the suspect had been during that time, what calls he had made, to whom, and from what likely location. In a nice little irony, the crime that they were investigating was that he was stealing cell phones from T-Mobile stores. But here's the question. This is third-party doctrine. 2 cases back from the 80s. If you share your checking account information or your banking information with your bank, third-party doctrine says that means you have also assumed the risk, in a sense consented, that it will also be shared with the government, even if you never intended for that to happen. You've got no choice in the matter. The second case was actually a phone case. You have no expectation of privacy in the phone numbers you dial. The contents of your call, yes, but not the phone numbers you dial. The fact that you have shared the information with the phone company means that the phone company can share it with the government. These rules were they never made sense. That's not consent in any way that we understand it, and how do you take yourself off the grid from the bank and the cell phone company? But the ramifications are so much greater now, because just think about, where are our documents? Most or many of them are in the cloud. There's no way that we aren't sharing almost every part of our lives with the internet and with our cell phone GPS tracker and with various other third parties. So everyone in my corner of the world is hoping that the court will take this opportunity to think about third-party doctrine and ask whether it can really survive. And I don't want to get too histrionic here, but in a sense, it's a question about whether the Fourth Amendment can survive, because these old paradigms that might have worked before we had such technology suffusing our lives really are simply not working here. And the last thing I'll say is I have some hope that this case could go our way, because in another cell phone case a couple of terms ago, the Riley case, the court actually unanimously held, and this is a slightly different context but relevant, that if the fact that you can search a person's person and receptacles on his person incident to arrest does not mean you can search everything in his cell phone. And therefore, one of the first times the court recognized that a cell phone is not like a paper diary. A cell phone contains the record of our lives, and that technology does sometimes require an entirely different approach.
Thank you, Professor. So I'm going to pick up on a First Amendment theme in a case that undoubtedly many in this room have heard about, read about. It's the Tam case. Simon Tam is the lead singer and I believe bass player in a band out of Portland, Oregon, known as the Slants. And for those who have not heard about this case, yes, the Slants is a derogatory term, sometimes leveled at Asian Americans, and that was the point of this group naming themselves the Slants. Simon and his colleagues in the band wanted to reappropriate the term, to use it in a way that sort of did away with its history as a derogatory expression. And in fact, much of their music is committed to the same aim. They actually devote a lot of their music to sort of parroting, satirizing anti-Asian American sentiments. So Simon wanted to trademark the term Slants for his group. He applied to the Patent and Trademark Office and was denied. And the PTO denied it under a provision of the Lanham Act called the Anti-Disparagement Clause, or at least that's what it's come to be known in recent times. And it reads very simply as follows: you may not use a trademark to disparage or bring into contempt or disrepute any persons living or dead. And the PTO officer said that's precisely what the name Slants does. It's antagonistic to a group, it's derogatory, and therefore your petition is denied. So Simon petitioned all the way up and ended up in the U.S. Supreme Court on his First Amendment challenge to this anti-disparagement provision in the Lanham Act. And he won unanimously in what was then an 8-justice Supreme Court. Now, the fact that it was 8 will end up mattering in terms of how we get to the finish line in this case, but he got all 8 justices to agree that the Anti-Disparagement Clause does indeed violate the U.S. Constitution, and he is entitled to his trademark under the Lanham Act. Now, how did we get there? Well, the court was unanimous for the easy parts, as so often happens, right? So the court begins working through what really is a litany that the government provided, a litany of theories as to why the expression here, a trademark, is not entitled to full-bore, strict scrutiny under the First Amendment. And the court begins to work through each of these theories. The first of them is that this is government speech. Now, for those who are steeped in First Amendment doctrine and know that there are all of these small categories and within them subcategories, government speech is where the government itself speaks. And of course, when the government speaks, it can say anything it wants. It can make viewpoint decisions. It often does. The government, as the majority says here, the government can say, you know, buy war bonds. It doesn't then have to post a poster next to it that says, don't buy war bonds. It can take a viewpoint position. So the government led by saying, this is really government speech, and therefore we can be as discriminatory as we want in terms of which trademarks we accept. In one of the more entertaining parts of the opinion, and I think from the perspective of the justices and clerks who would have worked on this paragraph, it had to be extraordinarily entertaining. The court says, how can this possibly be government speech? And I can't help but take a few of the statements and read them to you. You know, the court sort of trolls along looking for trademarks out there and says, well, what does the government mean then when it says make-believe, which is Sony's expression, or think different for Apple, or just do it, or my favorite, have it your way, Burger King's example. So the court says, look, this isn't government speech, so let's take that off the table. That's as far as the court goes in unison. Then there are some additional arguments the government had made. They said, well, look, if it's not government speech, would you believe it's subsidized speech, which is speech that is encouraged financially by the government, and that also historically warrants lesser First Amendment protections. And at this point now, half the court, it's Alito writing for himself, the chief, Thomas, and Breyer, says they work through each of these and say, no, it really isn't subsidized. In fact, if anything, the trademark applicant has to pay us to get their trademark, so how can we call it subsidized? And then there's this other theory the government advances that this is so-called government program speech, which is sort of a new idea, and it's kind of an amalgam of government speech and subsidized speech, and the court says that's a no-go either. And then the court gets to the final argument, which is really the one I think a lot of First Amendment folks had been looking for guidance on, which is commercial speech. Now, as many of you may know, commercial speech generally warrants lesser constitutional protections. It's subject to standards put forth in a case called Central Hudson many decades ago. And the Alito opinion walks through and applies Central Hudson and says, no, this kind of viewpoint discrimination fails even the Central Hudson test. So we need not decide whether, whenever you challenge something in the Lanham Act, the Trademark Act, whether Central Hudson applies, whether all of it is commercial speech. That was what a lot of people wanted guidance on, and they didn't get it. There's a footnote that says we're not giving it. So don't look to this opinion. Don't read too much into it. We're just not telling you whether commercial speech is the standard. Okay, very quickly then, what does Justice Kennedy, writing for himself, Ginsburg, Sotomayor, and Kagan say with regard to these subsidized government program and commercial speech? They lump them together and cut through with the sword in one fell swoop. They say, look, nothing is more viewpoint discriminatory than saying you can't be critical, you can't disparage. Like it or not, this is the worst kind of viewpoint discrimination, and the First Amendment won't tolerate it under any theory. So subsidization fails, this new government program idea fails, and critically, these four justices say, we're not even going to apply Central Hudson when it comes to commercial speech. If you're discriminating, if the government discriminates on the basis of viewpoint, as it does here, you still get strict scrutiny even if it's commercial speech. So we now have four justices, for those who do commercial speech work of any kind, four justices who have now added a twist to the commercial speech doctrine to say that heightened scrutiny applies to viewpoint discrimination even if it's commercial. Whether we'll have a fifth or a sixth justice join that in future cases, we have yet to see, but we have four on record making that point now. So that's TAM. Turning then very quickly to a case that I'm sure you've all read about on the front page of the paper for weeks. You probably have scrapbooks devoted to this case. It's received virtually no media coverage, but we're talking about it very briefly. I had argued this case and felt compelled to talk about it very briefly. So you can see my scrapbook. This is a case called Manuel versus Joliet, and actually we talked about it. It makes sense to talk about for one reason, and that is a sense of what the court does when it has only 8 justices. And this is the context in which folks talk a little bit about this case. Very briefly, this case involved an individual who was the subject of a traffic stop. He was patted down. They found pills. The pills, now the allegation in the complaint is that the pills were field tested and were negative for ecstasy, which is the drug the police suspected. He was taken back to the police station and he had his probable cause hearing before a magistrate. And the police officer said, I tested it and it's ecstasy. Therefore, the magistrate found probable cause and he was held pre-trial for about 7 weeks until subsequent testing occurred by the Illinois State Police. They found that it was negative for ecstasy and he was released. He wants to sue civilly for damages for the period of incarceration between the magistrate's finding of probable cause and his ultimate release. And the question is, what constitutional animal is that? Plaintiff argued, and this had clinics on both sides, very interesting case. So I was at Jenner at the time, and the University of Chicago clinic represented the city of Joliet. But wait, the Stanford clinic and a local attorney in Arlington Heights represented Mr. Manuel. Here's where the parties differed. It's fairly razor thin in a way. Plaintiff's theory was that this is a Fourth Amendment claim, and it's a Fourth Amendment malicious prosecution claim. We ought to borrow the elements of common law malpros and apply them here. Why does that matter? It matters because for anyone who's been involved in a malpros claim, you know that one of the elements, and it's fairly unique to malicious prosecution, is favorable termination. You cannot bring a malpros claim until you have prevailed in the underlying lawsuit that you're suing about. So that has the effect of delaying the accrual date for limitations period purposes for malpros claims. So if this is a Fourth Amendment malicious prosecution claim, it didn't accrue until his release, because that's when he prevailed in his underlying suit. If instead it's treated more as a traditional Fourth Amendment claim where the elements are being seized without probable cause, well, that claim accrued as of his initial detention when the lies occurred at the probable cause hearing. And this is where the parties differ. The city agreed that it is a Fourth Amendment violation. Both parties did, but they disagreed whether or not it has a favorable termination element or even other elements of malicious prosecution. So what it boils down to is, if the plaintiff is correct, it's a harder claim to bring because only people who ultimately prevail can bring that Fourth Amendment claim, but it accrues later, which helps plaintiffs. If the city prevails, more people could bring a claim, even people who were victims of initial Fourth Amendment violations, but who are later convicted properly at trial, they could bring a claim for that initial Fourth Amendment violation, even though it doesn't favorably terminate, but that claim accrues earlier. That's where the parties are. The court, in a compromise, 6 of the 8 justices say, look, we can all agree that it's a Fourth Amendment violation, which the parties had agreed to. And they said, so we're going to hold it's a Fourth Amendment violation. We're not confident the Seventh Circuit understood that. And there is some, depending how you read the Seventh Circuit case law. And so they made that holding, and then they went on and said, but let's let the Seventh Circuit resolve this accrual question, this favorable termination issue. So the real sort of meat of that debate remains on remand back before the Seventh Circuit, and we'll see what happens.
All right, thank you. I want to thank Mayor Brown again, and especially thank Steve Sanders for doing this every year. We all hear a lot of Supreme Court reviews around this time. We participate in them, but I've got to say this truly is one of the best year in and year out, and Steve does an excellent job organizing it. So thank you, Steve Sanders.
All I do is invite them.
I have 2 or 3 cases, depending on how you count, that I want to talk about very briefly today. And let me start by saying that I think the Supreme Court's term was, maybe the best way to say, is not a complete disaster for civil rights this year. It was not great, but it was not the disaster that it might have been. But there is one big problem. Well, there are a couple, but one big problem that's on my radar screen with regard to civil rights enforcement, and that's the future of Bivens claims for constitutional torts against federal officers. There are a couple of cases that the court ruled on, one in particular that I think ought to concern us all with regard to the future of constitutional torts against federal officers, and more generally access to justice, access to the courts, and access to remedies for violations of fundamental rights, rights in the Bill of Rights, and human rights. So the case I want to talk about is Ziegler versus Abbasi. This is a 9/11 detention case, but it's not a Guantanamo case. This is soon after 9/11, when the federal government was rounding up mostly Muslims and Arab men in and around New York based on tips that they were receiving and putting them in the Metropolitan Detention Facility in New York. So you had the feds instructing the local government about how to detain these individuals, and wouldn't you know, they were widely abused and tortured. So they turned around and brought a Bivens claim for Fourth Amendment and Fifth Amendment violations against 2 sets of defendants. On the one hand, they sued federal officers, the Attorney General, the FBI Director, the Director of the Immigration and Naturalization Service, the INS, which existed at the time. But then the second set of claims they brought against the local warden and the prison officials who were actually inside the prison. And those claims operated slightly differently, but we're going to gloss over those differences for our purposes. They also brought a conspiracy claim, which is important in the case. the court ruled in a way that narrowed Bivens dramatically and is leaving it just by a thread as far as I can tell. And in order to understand and appreciate what the court did to Bivens, I think it helps to understand how the court traditionally analyzes these Bivens claims. So what the court does is a two-step. At step one, the court asks, is the particular claim brought, is it in a new or different kind of context than previous Bivens claims that we've acknowledged? That's step one. Step two is, if it's in a new and different context, are there special factors that counsel against what the court calls an expanded Bivens claim to this new context, okay? Now, what the court did on step one is it narrowed this idea of context, and at step two, it broadened the idea of special factors. Let me explain. So at step one, what the court said is, look, we've recognized three kinds of Bivens claims in the past. We've recognized Bivens itself, we've recognized a Fifth Amendment equal protection claim by a congressional aide for sex discrimination against a congressman, and we've recognized an Eighth Amendment claim for lack of medical attention in the prison context. And what the court said is, unless your Bivens case falls, and I'm serious when I say this, on all fours with one of those situations, down to the officers, the constitutional claim, and the precise context of the claim, unless a new Bivens claim falls on all fours with one of those three recognized claims, it's a new context. Now, that's bad news for plaintiffs' lawyers who are bringing these constitutional claims, because what it means is almost everything is going to be a new context, right? Anything outside of those three recognized cases will be a new context and trigger the special factors analysis. So all's not lost yet, but when we look at what the court did to special factors, we see that the court limited Bivens even more. What the court did was consider everything from national security to the fact that Congress has not provided a context to, a remedy, to the idea that these plaintiffs might have had a habeas claim, right? As an alternative to a Bivens damage remedy. And then Justice Kennedy went on and on talking about this. What a hassle it is for federal officials to have to defend against Bivens claims in court as a kind of special factor counseling against a Bivens claim in the first place, as if they shouldn't build that into their job already, right? I mean, if you're going to violate constitutional rights, it seems like you ought to think ahead that you might get sued. But to Justice Kennedy, that's a hassle factor that counsels against a Bivens remedy. So for these two reasons, the court has left Bivens basically hanging by a thread as far as I can tell. And I think we're going to find out a little bit more in the next case I want to talk about. This is the cross-border shooting case, Hernandez versus Mesa. I'm going to talk about this just very briefly because the court didn't actually rule on it, but instead remanded the case for further consideration in light of the Abbasi case. What happened in this case is some Mexican youths were playing along the culvert that runs between the U.S. and Mexican border. And they were playing a game where they go up and they touch the U.S. wall and then run back to the Mexican side. As they were playing this game, these are like 14, 15-year-old kids. As they're playing this game, a Border Patrol agent comes by on a bike and nabs one of them. So Hernandez runs back to the Mexican side and hides behind a kind of beam that's supporting a railroad track that goes over the culvert. He hides behind, he kind of peeks out to see what's going on, and at that point, the Border Patrol officer shoots him twice in the face and kills him. His parents bring a Bivens claim for Fourth Amendment excessive force and Fifth Amendment violations against the Border Patrol officer. And the lower court said, as to the Fourth Amendment, it doesn't apply extraterritorially, which is an interesting and hard Fourth Amendment question, but that's what the lower court said. As to the Fifth Amendment claim, they granted qualified immunity. When the Supreme Court heard the case, we all thought the court was going to rule on the extraterritorial application of the Fourth Amendment, but the court didn't rule on that. What the court said instead is, look, we just issued the Abbasi decision literally last week, and so we're going to remand this case, this cross-border shooting case, to the Fifth Circuit to allow them to apply Abbasi and determine whether there's a Bivens claim at all. before they consider the extraterritorial application of the Fourth Amendment, before they even considered qualified immunity, although we have kind of an okay ruling on qualified immunity in the case. So we're going to see now what happens with this new Abbasi standard for Bivens in the cross-border shooting case as it works its way back up to the Supreme Court, starting at the Fifth Circuit. And we'll see in future cases kind of how this applies. But my prediction is that this is really going to limit federal civil rights claims.
Steve, I hate to interrupt. Do you want to say just a question about, for those who may not know, what a Bivens claim gives you? What is unique about Bivens?
Absolutely.
That it's money damages rather
than injunctive relief. Yeah, I'm sorry, I should have started there.
I just asked Steve to say a word about what a Bivens claim is for those of you who might not be familiar with the somewhat specialized concept in civil rights law.
Thank you very much. I should have started with that, and I apologize. So Bivens is an actual Supreme Court case that read into the Constitution a remedy, a money damages remedy for victims of Fourth Amendment violations by federal officers. And what we have been trying to do over time is, again, I'll put in air quotes, expand this Bivens context to new and different kinds of claims against different federal officers for different constitutional violations, but all for money damages. This is not an injunctive relief kind of thing. It's for money damages. And so in both of these cases, they're looking for money damages to make them whole for the wrongs that they suffered. I want to say just a quick word about Trinity Lutheran. This is the religion case, the scrap tire case in Missouri that involved Missouri's Blaine Amendment. The Blaine Amendment is a constitutional provision that Missouri has, along with 38 other states, that says that the state can't support religion in any way. It takes kind of a hard line on establishment and says the state and religion have nothing to do with each other. The state cannot support religion. So wouldn't you know, a church comes along and applies for a program for recycled scrap tires and money from the state to support their effort to repave their playground, which is used as part of their preschool. And the case, Missouri says, well, we can't provide money for that because of this Blaine Amendment in our Constitution. It says that we can't support any religion, and because you're a church, we can't give you money for that. And they cry foul. They say, well, that violates our free exercise clause rights. And so you've got a clash between this Blaine Amendment and establishment clause interests versus the church's free exercise clause claim, and the idea of play in the joints between the two. This idea of play in the joints says that what the government may do under the establishment clause doesn't lead to what the government necessarily must do under the free exercise, particularly in funding cases where the government is funding a program. It doesn't have to include churches or religion, but it may in some ways, and it doesn't have to in order to dodge a free exercise clause claim. Well, the court really narrowed this play in the joints pretty substantially in Trinity Lutheran, and what Chief Justice Roberts said for the majority is, when Missouri excludes a church because it is a religion, that is an adverse action against the church, and under free exercise principles, that triggers strict scrutiny, and Missouri just doesn't have a sufficient justification for its Blaine Amendment to uphold it against a strict scrutiny analysis. And so we're going to strike the Blaine Amendment, Missouri's and 38 other states. And Chief Justice Roberts said is we're going to apply this where there is discrimination against a church. And then he wrote a footnote 3 that's kind of interesting. Footnote 3 says, this case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination. So Roberts gets Kennedy, Alito, and Kagan for his full opinion, including footnote 3, but then Justice Thomas and Justice Gorsuch back out of footnote 3. They sign on to the opinion, but they say we're not on board with this footnote 3. And so we're all kind of left scratching our heads. Well, what does does all this mean, right? Is this a ruling that applies to playground resurfacing, or does it apply more broadly? We've heard from a lot of our friends that they're very excited about this case because it means that the government now has to fund religious schools, right, along with private schools when it runs something like a voucher program. I think that's not quite right for different reasons entirely, but that may be where the court's heading with this line of jurisprudence. We just don't know. So Trinity Lutheran, I think, is a case to worry about if you're worried about separation of church and state, because the court has substantially narrowed this play in the joints in the case on the one hand. On the other hand, the court's by its own reckoning has really tried to narrow the scope of the case, and we'll really have to see what happens in future litigation to figure out what this all means.
So thank you, everyone, for being here. And I think that the Trinity Lutheran case is a good indication of the potential for mischief that a Justice Gorsuch really presents for us. As probably everybody here recalls, Justice Gorsuch, then Judge Gorsuch on the 10th Circuit, wrote the 10th Circuit's decision in the Hobby Lobby case, which was one of the very few circuits, one of two circuits that actually found that the Religious Freedom Restoration Act and I believe the First Amendment in his decision was violated by the provision of the Affordable Care Act that required insurance companies or employer-covered insurance companies to cover contraceptives as part of the Whole Woman's Health Amendment. And I think that what we are going to see is probably a view of the First Amendment's free exercise clause that really turns the First Amendment on its head, at least for those of us who went to law school when I did or before. And so that's probably the perfect introduction for why increasingly my penchant for hyperbole is failing me. I think that when most of us gathered here a year ago, because there are a lot of friendly and familiar faces in the audience, very few of us, if any of us, actually thought that we would be looking at a full 9-member Supreme Court with the 9th justice appointed by Donald Trump. I cannot bear to use the honorific president in front of that man's name. And you know, I think it really does, you know, in a nutshell, capture what is going to be on the line in the next several years of Supreme Court advocacy and the concerns that probably everyone in this room share about the possibility of any future vacancies on the court. The issue that I'm going to talk about today that I'm perhaps most concerned about, and not just because of Chris Kobach's recent efforts trying to garner voting data from all 50 states and storing that data in the very safe confines of the White House and under the jurisdiction of Pence. But I do think voting rights is one of those areas that is really one of the most important issues that we face, and one in which there is a great deal of risk to our democracy. The Supreme Court's decisions this term were, just to borrow from Steve's presentation, were not horrible from a civil liberties outlook, but what's coming down the pike could very well be. So I want to start by talking just a little bit about the Cooper versus Harris case, which is the case that came out of North Carolina, in which the court found that the efforts by the North Carolina legislature to redistrict after the 2010 census did not pass constitutional muster. The two districts that were congressional districts that were at issue were the redrawn lines in District 1 and District 12. Both of those districts are frequent litigants, the subject of frequent litigation in the court. I think District 12 has been up there 5 times. But what the court found was that essentially the effort by the state of North Carolina to pack a majority of minority voters into these two districts could not be justified and certainly was not demanded under the Voting Rights Act and did not pass constitutional muster. And I think that there is, again, reason to hope in those cases. The majority opinion was written by Justice Kagan, and she was joined by the three other usual suspects as well as Justice Thomas. Justice Alito wrote a concurring opinion in which he was joined by the chief and concurred in part and dissented in part. But basically, the court seemed to continue to sort of back away from the notion that states could use race as the predominant factor in their redistricting decisions without having to justify the use of race under the strict scrutiny doctrine. And when the court took a quicker look or a closer look at what was at issue in those two districts, it found a great deal lacking. It found that with respect to District 1, even though it was not a majority-minority district, in which, I mean, the majority of the voting age population in that district are minority voters, the court said that when you looked back over the course of 20 years, District 1 had elected people to Congress who represented the choice of the majority of the minority voters in that district. This was quite frankly, not a polarized voting district. And at least 40% of the white voters in that district showed themselves time after time willing to vote for either a minority candidate or a candidate that was supported by minority voters pretty consistently over that 20-year period of time. And so the court found, or actually what it did was it upheld the district court's finding as not clearly erroneous, that really there was no real compelling governmental interest to redraw those district lines in a way that packed more minority voters into District 1. When you look at what happened in District 12, you see a similar result, but a little less deep reasoning, because in the case of District 12, the state of North Carolina did not even really attempt to satisfy the heightened scrutiny standard, and basically the court said, look, we again accept the district court's finding that race was the predominant reason that the state of North Carolina redrew these district lines. And once we've have a factual finding that race was the predominant reason for redrawing those district lines, it's up to the government to justify those redrawn lines by showing a compelling governmental interest. And here, North Carolina made absolutely no effort to justify or to show a compelling governmental interest, so the court didn't have to go the extra step of deciding whether it was narrowly tailored. It basically said this does not pass scrutiny. So what we have, I think in a quite oversimplified discussion of a 90-page decision, is the court recognizing that race is a suspect criteria when government is making a decision, even a decision that is ostensibly in furtherance of the Voting Rights Act of 1965, which of course was the justification that the state of North Carolina had really thrown out. Those of you who follow the voting rights controversies quite closely know that one of the issues that's been playing out between the lines is whether some of the states are manipulating the provisions of the Voting Rights Act in an effort to pack more minority voters in a fewer number of districts in a way that ultimately perhaps dilutes minority voting power, but in a somewhat different way than was initially anticipated under the Voting Rights Act of 1965 when it was first passed and when it was subject to subsequent amendments. What has been playing out over the years, and I think we see the discussion of it in the political gerrymandering cases, and that's going to be sort of the next thing I turn to, again, is an effort to pack more Democratic voters into a fewer number of districts in a way that perhaps wastes Democratic votes and has played out, I think, in favor of a growing number of states and their legislative bodies and their congressional delegations and sometimes their executive branches as being controlled by the Republican Party. So that is actually the subject of sort of two cases that the Supreme Court has granted review on for next term that I think are of a great deal of concern for civil libertarians and for people who really care deeply about the right to vote. The court accepted a case out of Ohio. It's called the Ohio Purge case, and it involves an Ohio election process whereby voters who have not voted over the last 2 years become the target for scrutiny and ultimately being purged from the voting rolls. A lawsuit was filed challenging this practice, and the Sixth Circuit Court of Appeals issued an injunction that basically prevented the Ohio election officials from using this particular process and restored to the voting rolls in Ohio, several thousand voters who had been purged under this process. The court accepted this case for review, and arguments will be heard this fall. It's, again, no secret, and this is where I get to give my usual, the ACLU is a nonpartisan organization. We don't endorse candidates or political parties, but, I think it is a fair statement to say that the Republican Party has been quite successful in passing numerous restrictions at the state level that are both intended to and do, in fact, suppress the ability of people to vote in elections on both a state and a federal level. And, the evidence that was introduced in the Ohio case in the district court found that this particular process was indeed part of the voter suppression efforts and was part of a large package of voter suppression efforts that had been passed by the Republican-controlled Ohio legislature that included also curtailing early voting rights in the so-called voting period where you could both register to vote and vote at the same time prior to the election. And again, I think that it'll be very interesting to see how that case is both briefed and argued. The other case that the court accepted for review came out of the Seventh Circuit and involved voting and it involved redistricting in the state of Wisconsin. The Wisconsin legislature, again controlled by the Republicans, passed a redistricting plan in 2011, again after the 2010 census, that a 3-judge district court, and just sort of a little footnote here, many voting rights cases are heard heard in front of a special three-member district court as opposed to an appellate court. That's sort of the court of first jurisdiction. Here, the three-judge district court, which included a Seventh Circuit judge, Judge Ripple, who was a Republican appointee, the district court, the three-judge district court found that the Wisconsin redistricting plan was intended to dilute the number of Democratic seats in the in the Wisconsin legislature, and indeed it actually had that effect, and thus it did not pass constitutional muster because it basically found that essentially there was an effort, successful, to discriminate against a particular group of voters. And so the Supreme Court has accepted that case for review. And again, for those who follow the voting rights area very carefully, the issue of political, and I guess I should really say partisan gerrymandering, that's a more precise term, because I think probably all redistricting is political in the broadest sense of the word, but partisan gerrymandering, which is something that is designed to give one political party an advantage over the other political party or parties, is something that the court has long been concerned about and has written tomes about, but is it fair to say has never really clearly articulated a standard by which people who practice in this area of law can really, sort of clearly ascertain whether something is going to flunk the test of being partisan or political gerrymandering that really in some ways violates the Constitution. And I think that we may be very close to seeing a test laid out in the case that comes out of Wisconsin and is going to be argued this term. And I think that this is, again, one of those cases in which there is a tremendous, tremendously high stakes. There's a lot on the line here because one of the oft-repeated points of analysis about what is happening in this country writ large in terms of redistricting and voter polarization has really pointed to an increased trend of partisan gerrymandering, of really contributing to these kinds of hyper-partisan districts in which more moderate candidates, whether Democrat or Republican, but more moderate candidates really don't have a chance of surviving a primary process. And so a lot is at stake, I think, not just for the political parties, but for democracy writ large. And it will be really interesting and I think a little bit scary to see how Judge Gorsuch votes on these cases. So I think we are in under 10 minutes and can go from there.
Right. And that provides a good segue to the question I'd like to pose to the panel. If you have questions about the cases that were discussed or other cases, hold them. We'll save a little time at the end. But this year we're varying the format slightly. Wanted to just get the thoughts of the panelists more broadly, since the court has been through some significant change, some would say turmoil, with a vacancy that went unfilled for many months and affected the court's docket. It's now back up to full speed. Wanted to sort of get the views of these veteran and expert court watchers about the current state of the court and maybe what to expect next term. So Colleen talked about things that used to sound like hyperbole not being so much hyperbole anymore. So let me pose a question to all of you. This is from Mark Stern, who writes about the Supreme Court for Slate. And I think he wrote this the day after the Trinity Lutheran decision came down with Justice Gorsuch's concurrence in that. So Mark Stern writes on June 26th, on Monday, Justice Neil Gorsuch revealed himself to be everything that liberals had most feared: pro-gun, pro-travel ban, anti-gay, anti-church state separation. He's certainly more conservative than Justice Samuel Alito, that's saying something, and possibly to the right of Justice Clarence Thomas. You didn't think that that was possible, humanly. He is uncompromising. He is an uncompromising reactionary and an unmitigated disaster for the progressive constitutional project, and he likely will serve on the court for at least 3 more decades. Discuss. And I want to keep this conversation, so just brief reactions to Justice Gorsuch so far. Is this an overstatement, or is this what we should expect?
Well, I was going to say, I wish he would say what he really thinks. But unfortunately, again, I don't think it's necessarily hyperbole, but I think the way to think about it is, rather than focus on the merits, where he'll come out on the merits, what is jurisprudence? What kind of a justice is he going to be? And I think there are a lot of disturbing tea leaves on that. For example, in the Pavan case, which was a case about whether a hospital would give a birth certificate to same-sex couples with both names on it, which I think most people on the court thought squarely fell within the ambit of what was already decided by Obergefell. Justice Gorsuch, dissented, which I think raised the alarm that his fealty to settled precedent might not be all that strong. So that's one type of tea leaf. Another type of tea leaf does go back to the travel ban, the fact that there, too, he dissented from the refusal to simply overturn the entire ban, and this might raise a fear about what one of the many things he promised us in his confirmation hearings, that he would provide a real bulwark against, and be willing to raise alarms about overweening executive power. So those are just 2 on my list. I have a much longer list of things to be afraid of about Justice Gorsuch, but I can come back to it later if I have time.
Yeah, I won't add much to that. I mean, I think that there is, yes, all of those indicators, I think, are there in the various separate writings that he provided in a very short period of time at the end of the term. I think if there's the most striking characteristic that cuts through all of it, and I think this builds on what the professor was saying. I mean, it's the boldness and the confidence of someone who is that new to the court. Looking at his dissent in Perry, where he is essentially, which was kind of a sleepy case, but where he is really calling out the majority on some basic principles of separation of powers. It seems to me, and I'm not the first by any stretch to sort of remark on that, but I think that there is a real sense of confidence, and I think that confidence may well translate into perhaps less regard for settled authority, certainly a willingness to call out other members of the court very early on in one's tenure. It is a small boat in a very long river serving on that court, and so we'll see how that plays out as well. And interpersonal dynamics are not irrelevant on a court like that.
And Steve, the Chief Justice Chief Justice Roberts has from the beginning talked about wanting to craft decisions that gathered big majorities or were unanimous, to not have a sharply divided court when it wasn't necessary to do so. Is Justice Gorsuch bad news for that project of the Chief Justice?
Well, I think so far, absolutely. And what's striking to me about, in addition to the things that we've heard from Susan and Mike, is that he's very aggressive in ways that seem almost gratuitous and leave me really kind of puzzled. So, for example, he's written a lot just in his very short time on the bench. He only sat for 10 of the cases this term, only in the last term, and yet he's managed to write just a ton of stuff on things like cert grants or cert denials. And what's really puzzling about this is he'll weigh in, for example, in a concurrence on a cert grant. You just kind of wonder what he's doing, right? And he, in a couple of instances, I think, has thumbed his nose not only at other justices on the court, but in particular the chief, again, in almost gratuitous ways. So you wonder whether he's asserting his independence, which I suppose is a possibility. Maybe he feels like he needs to pull his weight on the court, and he's only been there for a short period of time, and this is his way of pulling his weight. Or maybe this is what we're going to see more of. If it's what we're going to see more of, I think we ought to be very, very worried.
I'm very worried that he's an ideologue, and I think that both women's reproductive rights as well as gay rights and religious liberty are quite at risk. His decision as a circuit judge in the Hobby Lobby case was quite disturbing in that, from my vantage point, and even though ultimately the Supreme Court ruled 5-4 in a way that accepted much of Judge Gorsuch's opinion, it really turned the free exercise concept, even though it was decided under the Religious Freedom Restoration Act, on its head. And just to cut through really 50 years of Supreme Court doctrine, the court had long held that the right to believe or the freedom to believe was absolute, and appropriately so. It's nobody's business. It's not the government's business telling any of us what we should believe. I mean, that is really, quite frankly, the essence of religious liberty. It's an expression of faith between the individual and his or her concept of the Almighty. And notwithstanding that near absolute support that absolute support for the right to believe, the court in a series of cases over decades basically said that there's a difference between the right to believe and the right to act, even if you're acting in ostensible conformity to your religious beliefs. And government can act to regulate conduct, even if it is claimed by some to violate their religious beliefs. And sort of a subset of that it was really the recognition that your individual right to believe did not carry with it the right to impose your beliefs on other individuals, save for your children until they reach the age of majority. What stood out for me then and now about the Hobby Lobby decision is that the court found that, and Judge Gorsuch had been, again, the one who articulated this on the 10th Circuit, that the right of the Hobby Lobby Corporation, even if I'm going to grant that it was closely held, that their right to belief overrode the beliefs and the medical decision-making of thousands of their employees. And that was just, a complete, turning, these concepts of religious liberty on their head in contrast to, like I said, decades of jurisprudence. And so I'm very, very worried that Justice Gorsuch, who by all accounts is a devout Catholic, will use his, very religious Catholic beliefs to give a muscularity to the free exercise clause and to basically allow individuals to impose their religious belief on employees, on customers. I'm very worried about the wedding cake case. In contrast to, we go with settled jurisprudence. I mean, in the areas of public accommodations, like being, everybody being, able to be served on an equal basis at restaurants, in hotels, and in boarding rooms is really a doctrine of law that has been well recognized and protected since really the civil rights era. I mean, there were many, there was bloodshed and in 1960 in the 1960s, predating the passage of the 1964 Civil Rights Act, and again this notion that a business owner is able to essentially say, no, my religious belief is going to be allowed to restrict people's, access to a public accommodation is very scary, because I think it is a slippery slope.
I want to ask one last question to the panelists, just for a quick reaction. So one of the, a case that a little bit was decided, but the big part has been put off till next year, the Trump travel ban. Some call it the Muslim ban, the order restricting access to this country. The court this year allowed it to go into, lifted a stay, allowed it to go in force in a limited way, but then we'll hear arguments and decide the constitutional questions about the travel ban next term. We don't do a lot of predicting on this panel, but just really quickly, so we have some time for questions too. Any thoughts about what you think the court is going to do, or what should we interpret from the fact that the Supreme Court, unlike all lower courts, let the ban go into effect in part?
Well, I think the Bivens case is troubling here as well, because it didn't only seek to hold Bivens to pretty much to its fact. It also contained language that might have been gratuitous about the importance of deferring to national security, and some people interpreted that as a little bit of a red flag. But as to your other question, my reading of the case was that the majority went out of its way to say that they were not saying anything about the merits of the case. And here again, Judge Gorsuch seemed, if I remember correctly, to, could I say, misstate the majority's ruling by assuming that the majority had weighed in on the merits just by lifting the ban? Does that seem fair to you guys?
Yeah, he says, the legal standard for lifting it would be a likelihood of success in the merits, and he says, I fully embrace the majority's implicit conclusion that there was a likelihood of success in the merits here. So I do think there was. I think you put it exactly right, Susan. Yeah.
So my prediction is that the case will be moot when the Supreme Court hears it, and that the court will rule as such if it gets a chance. And why I say that is I think the interesting player to watch at this point is not the court, but rather the administration, and to see what kind of monkey business they can come up with to either try to unmoot the case or implement a new travel ban that then will start this whole thing all over again.
Yeah, because the lifting that they did does start the clock again, and the clock may well run before the court has a chance to. So it could be a really ingenious move by the majority to sort of moot this case before it gets around to October. So.
Any thoughts? Okay, we've got time for a few questions from the audience, if there are some. So I see one hand back there.
Hi. One of the cases that I was following was an immigration case, the Sessions versus Morales-Santana. Do you think it moved the needle at all on sex discrimination and immediate scrutiny?
Anyone know that case?
I do.
Okay.
Yeah, I think it did a little bit, and my recollection is that Justice Ginsburg wrote the majority opinion in that case, and so I do think it moves the needle a little bit, but not perhaps a whole lot. I mean, in some ways, it seemed like it appropriately sort of cut back on an earlier case involving immigration and citizenry of a child who'd been born to one parent who was an American citizen and one who wasn't.
Other questions? Yeah.
I have a question about the Carpenter case, where I've heard an argument on the other side is that these guys that get the cell phone records, or the cell phone records are generated by the third party. So that, what does that mean? And also the other part of, Riley, you have physical trespass. So how would we navigate that?
Susan, do you
So the physical trespass, you mean in Riley because they seized the actual cell phone? Is that what you're?
Yeah, that's right.
Yeah. Well, I think it was not. I mean, as I said, the search incident to arrest is a separate context, and of course there you've already arrested someone, so he has given away some of his rights, whereas in Carpenter we're dealing with the question of whether the government conduct is even a search at all. So the context is not the same, but your physical trespass issue, I think, comes up a little bit more squarely in the Jones GPS case, and I'm glad you raised that because I did want to mention that also. That was the case that involving 24/7 GPS tracking of over a period of a month of the suspect without any kind of probable cause or warrant. And there, everyone I hang out with hoped that the court would resolve the question of whether 24/7 tracking is a search, because it's always been the case that a police car could follow a car on the road and you don't have an expectation of privacy when you got on the road. But technology means you can do this 24/7. Does that change anything? Does it create a mosaic, as one of the concurrences called it, where you can piece together parts of someone's life that normally couldn't be pieced together? The court dodges this question by relying on the fact that the GPS was physically placed on the car, so it actually hasn't answered this question. So I'm wondering if that's partly where your question is coming from, that part of what the court's been doing with search doctrine is going back to the roots of search doctrine and saying a search used to be a physical trespass and it can still be.
I want to just mention the second part of my question.
Oh, yeah.
I'm sorry, I didn't speak into the microphone. Was the idea that, which I disagree with, the idea that a third party creates the record, the phone record itself. I think that the satellite system is the third party has somehow created it, even though I feel like you should have some right to privacy there. If the third party is creating the record, can that be covered by the Fourteenth Amendment?
There may be something I'm missing, but it seems to me that this is not different from other third-party records, like the phone company creates the phone bill and the bank creates the banking statement. So unless there's something I'm missing in your question, that doesn't distinguish it, does it? Or you're saying that that's an argument why we should uphold third-party doctrine?
I've seen that argument articulated.
Yeah.
I disagree with it because it's giving away your GPS locations.
Yeah, just a really quick point. You look at the lower court opinion in Carpenter, it does what so many courts do when they're dealing with these new technology cases, chiefly in the Fourth Amendment context, and that is it tries to find an analogy to something that's in, old school, right? And so in that case, the majority looks to, mail and says, well, the marking on the tracking on the outside of an envelope is really what we're talking about here, and the cops can always look at that. To me, I think, who prevails in the Supreme Court, and like so many of these cases, may well turn on who comes up with the better sort of non-technological or low-tech analogy to what's going on here, because that really becomes the basis or so much of the analysis.
Don't you, this is one of those areas where I am concerned that Gorsuch will be worse or not as protective as Scalia was. Oh my God, the ignominy of me thinking, oh my God, I really wish Scalia were back. But I mean, and some of the cases, and the Jones case, I believe was one. Justice Scalia was protective, and Kayla was another one involving sort of the infrared, use for growing marijuana plants inside.
And not because he was a civil libertarian, but Justice Scalia would say, my originalist form of constitutional interpretation just leads me to this result.
Exactly.
It just happens to be a progressive result progressives like. Justice Gorsuch is said to be an originalist as well. Is he really an originalist, or is he just a conservative?
A statist,
or just a pragmatic ideologue, which is more. I completely agree with Colleen on Confrontation Clause and Fourth Amendment. For example, Justice Scalia could surprise us, and did on many occasions, because he did follow the courage of his jurisprudential convictions, and I think that is where the jury is quite out on Justice Gorsuch.
Other questions? So we have one here.
My question is very early in the stage of litigation. Today, a court in D.C. is going to make a decision on an injunction against the Presidential Commission, requesting, whatever you want to use as a verb, 50 states to give their voting records. Involved in that case is separation of powers, I think, between Congress and the executive branch regarding privacy, because Kobach has argued the privacy issue of the general administration does not apply. He's changed the position in his argument before the court the other day. Also, perhaps ironically, also involved is the issue of states' rights versus federal government. What do you think is going to happen, using your crystal balls, not regarding today, but litigation coming forth, and the U.S. Supreme Court decision, which I think it may go to?
So I actually am going to hold out a small bit of hope that perhaps Chief Justice Roberts' decision in the Affordable Care Act that basically said states could opt out of the Medicaid expansion, under sort of grounds of state autonomy, will, depending on how carefully the commission was crafted, and dare I say, I have not seen a whole lot of careful craftsmanship, legal craftsmanship coming out of the Trump Sessions administration, that might provide some fertile grounds for arguments, in addition to, in some cases, including Chris Kobach's state of Kansas, there are state laws that prohibit the release of some of this information, which I think presents a really, again, interesting federalism question. I think there are all sorts of very interesting spending clause arguments rolled up in this, as well as, 10th Amendment questions as well.
Might it be, under the Rehnquist Court, Justice Scalia and others were pioneers of something that's been called the anti-commandeering doctrine, which, essentially is intended to prevent the federal government from taking over or giving orders to the administrative or lawmaking apparatus of the states, unless the federal government's willing to pay or bribe them or give them, otherwise incentivize them. And I think, Colleen, that's what you're probably having in mind with the 10th Amendment, right? So might this be a place where progressives finally like the anti-commandeering doctrine?
This could be, and there is another anti-commandeering case before the court next term that I think will give us yet another data point on where Gorsuch stands on these questions. The New Jersey sports betting case, which is an interesting kind of twist on commandeering. So I think what the court has to say in that case will help us understand kind of where it may be going in an issue like this.
Okay. I think we can take one more quick question if there is one. Anyone? Okay. All right. Well, thank you once again for another successful event.